Today, what I wanted to talk about was negotiating your child custody case. And this really applies to any case that any person is going through. Just like, when you go to buy a car, you have certain things on your wish list. Like, I know when I go to buy a car, it's like, I want the car fully loaded. I want everything. I want every option that is going to make my life the way I want it to be included in that car. But I go into the car dealership usually, and I realize that there are certain costs associated with each of the options that I want. And so then I have to kind of evaluate what it is that I really want and what's most important to me and what I can afford. And this is the way that you kind of have to evaluate your child custody case. Now, there are rare situations where one of the parties might be in a situation where they're holding all the cards and they have all of the bargaining power. The other party is at a complete disadvantage. These are rare situations. Often I feel that each of the parties have things that are great for their case and maybe not so great. And so they each have to evaluate what their strongest positions are, what the things are that they want the most, and most importantly, what it is that is best for their children. And those are the things that they have to advocate for the most. This doesn't really apply to a child custody case, but I want to give you an example. So I've had many divorces over the years where parties are fighting. Often it comes down to the barbecue. I don't understand it, but people fight over the grill all the time. And the Christmas decorations. They fight over the Christmas decorations. So I have been in so many situations where people, it comes down to the wire, we're dividing up personal property, and then they start arguing about elf on the shelf. And I've really had that happen. And I've had a judge tell me, are you kidding me right now? You're arguing over elf on the shelf. So you have to think about what it's going to cost you to push that and what you have to gain against what you might have to lose. So in your child custody case, if you're fighting for something that may not be as important, say for as the overall, what kind of custody arrangement is it going to be, joint or sole, or what's the parenting time going to look like? Like those are the big ticket items there. And if you're fighting for something or arguing over something that maybe is not quite as important, then that's really distracting from the strength of the bigger argument that you might have. So one of the first things that I teach in almost every one of the courses that I've created for you guys is you have to look at what's at stake. What are all the things that are in dispute in your case, in your custody case? Are we talking about decision-making or legal custody? Are we talking about parenting time? Are we arguing over holidays? Are we arguing over vacation? Are we arguing over transportation? Are we arguing over child support? Are we arguing over whether a third party can watch the kids if the parent who the kids are supposed to be in the care of is not available? What are the things that are at issue? And then you have to decide what are the things that are most important to me because they're going to make a difference in the life of my kids. And those, I would say, the top 3 to 5 things are the things that you have to focus all of your energy on. And you have to be willing to compromise on some of the, quote, not so huge things. In the past, I've had clients who have told me, I want that bed at all costs. And this is obviously not in the context of a custody case, but they tell me, I want that bed. So we end up spending so much time and attorney's fees and money arguing about a bed, and they pay more money than the bed is actually worth. And there have been times when I've actually told my clients, like, I will buy you a bed, I'll buy you a new vacuum cleaner, like, let's just get past this. So if you have an attorney, don't make your attorney do that. If you don't have an attorney, figure out what the biggest needle moving things are going to be in the lives of your children and focus on them. It's always about the kids first. It's always about the best interest of the kids. You have to remember that. You guys, I preach best interest, best interest, best interest. I tell you, if you haven't already, you have to go to commandthecourtroom.com and download the best interest checklist because that's what it's all about. So look at that checklist, apply it to your case, apply it to your children, and figure out what is going to work best for them. What is best for them in the long run? You have to get crystal clear on that, not only for yourself, because once you're clear on it, that's how you develop your entire strategy. But you also have to be clear on it because you're going to have to articulate what you want to your judge at some point. And if you're not clear on it and you can't look yourself in the mirror and say, this is what I want and why, you're never going to be able to do it in front of a judge. You have to do it in a convincing way. I started off my career as a prosecutor, and I was a prosecutor for the county, for the state for a few years. And after a few years, I transitioned and I started doing criminal defense work. So this was a long time ago. It was back in 1999. So 21 years ago, I started doing criminal defense work. As a criminal defense attorney, a lot of the cases that I had, the evidence was overwhelming. Like, the state really didn't charge people unless they had enough evidence to convict somebody beyond a reasonable doubt in front of a jury. So as a defense attorney, it was often difficult, even though the burden of proof was on the state, it was difficult to defend somebody because there was so much evidence against them. But I had to stand up time and time again in front of juries and argue that my client be exonerated because of whatever, XYZ. Oftentimes they just argued that they should be exonerated because the state had not sustained its burden of proof, because the state had not proven my client guilty beyond a reasonable doubt. But a lot of times when I was arguing to the jury, I could just see people zoning out or they were shaking their head at me. It made me feel horrible inside, like I was shrinking inside because nobody believed what I had to say. And I thought I was a good criminal defense attorney, but I could have been better if I had really been more solid in my belief, about my client or the evidence or whatever. But I couldn't always be. So I want to loop that back around to what we're talking about in your case. And that is, if you're going to advocate and negotiate that you should get some sort of arrangement with your kids, an equal parenting time arrangement or shared custody, or that the other parent should not get any parenting time or supervised parenting time, you have to be not only convinced in your heart of hearts, but you have to be able to articulate it to the judge. And it's more than just appealing to the judge's emotion. You have to back it up with real evidence. And that's where I saw Raul saying, document, document, document. Absolutely, Raul. He's got it down. You have to back up what you're saying with real hard evidence, with the proof, with the facts. So it makes it easier for sure to be more convincing if you have the backup. But, get used to looking at yourself in the mirror and saying, this is what I want and why, and do it with your 3 to 5 points, because then when you get to the place where you have to advocate for yourself, whether that's in mediation or a trial or a temporary orders hearing, you're convinced and you're convincing. Another example of this is how when I first started doing Command the Courtroom, there's a huge difference between my early videos, like from a few years ago, and now. Now I'm much more comfortable talking just off the cuff. Then I was a lot more timid. I really hadn't embraced my own experience and my own authority. I really didn't trust myself as much. But the more that I started talking about it and talking about the best interest of the children and talking to you guys, the more I became convinced about, how I'm helping people and how I know what I'm talking about and how I have the experience to talk about this. So the more you talk about your case with other people who are interested and who are supporting you, and the more you talk about it in the mirror, and the more you write about it and journal and build your case and do the things that I show you how to do in the 21-day custody challenge, the more convincing you're going to become to the court.